Good morning, everybody. Good morning. Okay, there's coffee in the back to wake you up. We're just starting. So let's talk a little bit about wage and hour law. Normally when I present on a topic such as FLSA, which is Fair Labor Standards Act, FLSA, it's not exactly a scintillating topic. So I'll generally start with a joke that's relevant to the topic that I'm discussing. However, we've got so much to talk about today, and I know there's some people in the back that cannot think that I'm going to talk for a short period of time. I'm going to save the joke and leave that as a teaser for you to approach me after the fact and ask me what my FLSA DOL joke is, because there's only one that I know of, and I know it. So come up to me afterwards and I'll tell you the DOL joke. We do have a lot to talk about, but in preparation for this talk today, we were going through the slides even last week, and what a difference a week makes. We were talking about this topic that, frankly, John and I have talked together and separately at least a dozen plus times since the news came out about the changes to the wage and hour rules. And all of a sudden on Thursday, bang, the world changes. And we'll talk a little bit about what just happened, but now we're scrambling around to think about what to talk about. Fortunately or unfortunately for some people, I think what we're going to be talking about is still going to be relevant, but they're trying to screw with us as much as possible by throwing these curveballs at us. So when we hear the news on Thursday, I was reminded of Gilda Radner and her character of Emily Latella, if you remember her. As Peter said, I'm a dinosaur, so I'm showing my age that I know Gilda Radner stuff. But she was famous for the catchphrase of "never mind," and that's sort of what we're facing right now. We had all geared up for these big changes on December 1st, and then all of a sudden last Thursday, there's an announcement that 21 states and the U.S. Chamber of Commerce all decided to file a lawsuit this late in the game to try to stop the DOL from passing along these rule changes. And so we're chugging along, we're out there, we're speaking, we're educating, lots of my clients, lots of John's, I'm sure both John's clients are starting the process of going through their employee roles and auditing and trying to figure out whether their employees who you needed to increase the wage rate to, whether you had to drop them back down to hourly, the culture issues, the HR issues, the handbook issues, all of these things, and then this drops. So these two groups all descend on the same court in Eastern District of Texas, which is typically a very friendly court, but my blogging compatriot right here, always on the top of things, says, yeah, good court, they drew a bad judge. So apparently the judge is an Obama appointee, so they thought this court was going to be the friendliest place possible for them to try to stop the DOL's effort and get a preliminary and permanent injunction to prevent these rules from going forward. But you know, sometimes you got to get a little lucky. They didn't get lucky. They drew a bad judge. So with all of that, their lawsuit, I have to say, has a bunch of different points to it, some of which I don't think hold a whole lot of water. One of them is a fairly interesting argument, and I was just talking to someone from the city of Cleveland who's over here is joining us today, and this point was fairly interesting. And one of their arguments is the federal government and the DOL shouldn't be legislating, for lack of a better word, and creating a almost doubling of salary rates to determine the exemptions for white collar, because that puts an enormous burden on state governments, and the federal government shouldn't be in the place of dictating what state government budgets and labor costs should be. That's, I think, the most compelling argument of the few that I've seen that they're throwing out there. But due to the late filing and with a December 1st date looming, there's a lot of doubt as to whether or not this effort is going to bear any fruit. So what do you do if you don't think that their efforts are going to be fruitful? And that is, be prepared. The old Boy Scout, Girl Scout, Cub Scout motto, be prepared for everything. And as a result, just when we thought that all of our great teaching was going to go away and we were just going to sit around and tell jokes today, we can actually go forward and continue on with what I think is going to happen anyway, which is the rule changes and everything that we're going to be talking about are going to come down on December 1st, and you've got to be ready and prepared for the outcome of that change. Okay, so this is not a wage and hour 101 class, but I do want to make sure that we all are in agreement that we know some of the Fair Labor Standards Act's basic tenets. So first and foremost, the FLSA puts out the notion of a minimum wage. So $7.25 is the federal number. For Ohio, it's $8.10. I have lots of clients that have multi-state operations, so you need to be up on the wage hours rules and regulations and statutes of the individual states. They vary greatly. One of the primary places we see that the state laws differ is in how you pay your employees and what you can do with their last paycheck. That varies greatly state to state. Some states have very punitive rules when it comes to holding on to that last paycheck. Ohio is not one of them. But other states that surround us have very, very punitive rules with multiples on the amount and attorney's fees and interest rates and all kinds of other things. So you need to be cognizant of state rules when you're dealing with minimum wage and how you handle your wage and hour issues. Overtime requirements, exempt versus non-exempt. Obviously, we're going to spend a bunch of time on that, but just a show of hands, how many people out there think they know the difference between an exempt employee and a non-exempt employee? Come on, put up your hands, you're so sure. Let's go. That was probably 3/4 of the room think you know the difference between an exempt and non-exempt employee. Well, I'm here to tell you, you probably don't. And it's not your fault. It's not your fault. These laws are tough to interpret. They're very tough to interpret in the real world. And as we'll see in a little bit, some very, very large companies with very professional, very well-schooled HR departments, with in-house counsel to beat the band, with outside counsel to beat the band, they get it wrong every day and they get hit for humongous numbers. So when I slightly mock you and say you don't really know what an exempt versus a non-exempt employee is, don't feel bad. You're in very good and rich company. The other big thing for FLSA, and it still shocks me to this day that I'm answering questions about it, but it creates overtime based on a 40-hour work week. Not an 8-hour day, a 40-hour work week. And perhaps because of the dinosaur nature of my practice and this state of Ohio that we live in, we have a rich history in unions. And as a result of having a fairly high percentage of unionized employers in this state, this state's companies have tended to mimic or mirror union policies on occasion. So I still bump into companies to this day that pay overtime on an 8-hour day, and when I tell them that's not consistent with federal law, they stare at me like I'm crazy, and they've never heard such a thing. Well, it's true. It doesn't matter how many hours an employee works in a day, it's how many they work in the work week. That's the federal law and state. The other thing people get wrong all the time is that paid time that is not actually worked does not have to count towards the 40-hour work week. So a holiday on a Monday, 8 hours, that time does not have to be computed into the 40-hour work week for overtime purposes. You can pay a straight 8 for a Memorial Day or a Labor Day, things like that. But people do that incorrectly under the federal law. It's perfectly fine to do it. It's just not required. And some employers have taken a fairly aggressive stance, and they try to mimic old-time CBA rules when it comes to wage payments, because they want to try to keep unions away from their companies, so they try to take their policies whenever possible. That's one. That's one that you see all the time. Some other common violations, and we'll be getting into the violations, but I list them here: independent contractors, breaks. The DOL is a very cute term for what employers do to their employees, and that's suffering them to work. It sounds so terrible. They've got a chair and a whip, and they're smacking them over the head with it and forcing them and suffering them to work, but that is the term that's used by the DOL. And then rounding errors. So you are going to see, as a result of these changes, someone was just saying before, I think it was Lamar, that came into me before and said Congress is made up of mid-20s, high 20s percentage of lawyers, and they're just there to pass laws and regulations that help their own. I don't disagree, but I think there's got to be a couple of payroll specialists in Congress too, because this is a wonderful time to be a payroll company, because the more complicated these rules get and the more difficult it is to administrate, the more people are going to be relying on high-tech fingerprint scanners, ocular scanners, card swipes, IMAX at people's stations in order to track time effectively and efficiently. So it's a wonderful time for those deals too. But with technology comes problems. So I see a lot of times, I'm sure John does as well, that when you go out to a company and they've got these wonderful high-tech systems in place for timekeeping and time tracking, they rely on them to their detriment, and they have automatic deductions for lunches. They round enormous amounts of times on the front end and the back end of a workday, and those rounding errors can cause a great deal of liability and litigation down the road. Okay, so let's talk about what you all think you know, and that is exempt versus non-exempt and how to do it. This is a fairly handy-dandy flow chart and test that, frankly, I stole somewhere with, I can assure you, full copyright infringement in place. And what does this show? This shows the thought process that you should go through when you do your analysis for exempt versus non-exempt. And by the way, if any of you are squinting at the screen and you can't see it, if you want to give us a card afterwards, we can send you the presentation to you so you don't have to squint and stare at it. So first step in the process, you have to do the salary test. So currently, the salary test is at $455 a week, or $23,660. If you are under that amount, there's no question about it, you're non-exempt. You can stop the test right there. Now, this is coming from defense guy, but that $23,660 is low. It's a low threshold, very low. Should have been changed probably, I don't know, 10 years ago. Hasn't been changed. It needed to be changed. It absolutely needed to be changed. However, what is the nuttiest state of the 50 states that's out there? California, I hear, right? Yeah, California. Montana's pretty weird, but California's weirder. All terrible laws start in California and migrate east. So, wonderful place to visit, but you do not want to be an employer there, I can assure you of that. So what did California do? Is California a cheap or an expensive place to live? Expensive. So California looked at this issue a bunch of years ago and they said, wow, that 23,660, that number is way too low. We as a state cannot allow that to be the threshold for whether someone's exempt or not. So we're going to change it as a state. We have the right to go above the federal. We can't go lower, but we can go above it. What did the state of California figure that number should be in the expensive, nutty state of California? Answer? It was, well, whatever it turns out to be. You might not be that far off. It's $35,000, okay? And it's gone up year to year to year, but when they first changed it, it was $35,000. So what did the federal government just do? The federal government said, well, let's look at the nuttiest state, one of the most expensive states, and let's go 12, 13, 14. Initially, they wanted $50,000. They wanted $15,000 more as the threshold over the nuttiest state and an expensive state of California. That's what the federal government just did. And they didn't say, well, what about those silly middle states, Nebraska, Kansas, all those states where cost of living is super low. They said one size fits all. What about nonprofits? What about small business? What about religious institutions? Nope, no exceptions. There's an exemption for teachers and things, but for schools, but one size fits all. And so they initially came out with $50,000+ as their number. They were talked down, and it's now $47,476 is the number, or $913 a week. So that's the new number that's coming, and my phone is ringing off the hook with companies, clients, nonprofits that I represent, small businesses saying, what do we do with this? Simultaneously, there's an effort downtown, you might have heard of it, for $15 an hour. Now they've changed their tune to $12 an hour minimum wage. All of these things are shocking changes to the labor budgets of companies that might not be able to afford it. So that's the big switch, and that's what we're preparing for. So just with that first step, ask yourself the question, under the current test until December 1st, $23,660. If they're not making that, they're automatically non-exempt. If they make more than that, they might be exempt. They might not, but they might be. With the new test, it's $913 a week and $47,476. If they are under that number, without a question, they're non-exempt, and you have to pay them overtime on a 40-hour work week, and you've got to start tracking their time in some manner, and we'll talk a little bit more about that. If they're over the $47,476, then you move on in the flow chart to step 2, and that is, what do they do? Do they fit into one of the exemptions? And I list most of the exemptions here: executive, administrative, professional, computer professionals, outside sales, not inside sales that occasionally go out, outside sales who don't come back to the home base with regularity, and highly compensated individuals. Under the old test, currently, it's $100,000. Under the new test, they jack the number up to $134,000. So everything is increasing. So if they get over that threshold, then you start looking at what they're doing and whether you can fit them into one of these exempt classifications. The grayest classification of all of them, administrative. So that is the tough one. That is the one that all the companies get stung on, and as we'll show in the class action section, some very big companies got tripped up on the administrative exemption. Once you do the analysis, does this employee, and I've done the exercise with clients of mine already, you go through the entire payroll, all of your people, go through their jobs, look at their job descriptions, look at their pay scales, and you've got to decide, am I going to add duties to these people, take duties away, bump them up over the $47,000 threshold, keep them where they are, track their time, pay them overtime. These are all the things that are coming home to roost right now with this change. So that's step 2 of the process. Once you've figured out whether or not somebody could fit within one of the exemptions based on what their job description is and what they should be doing, step 3, make sure they're actually doing what their job description and what their job requires them to do to fit within the exemption. Because you can give somebody the greatest job description in the world that makes them sound like they've got all kinds of independent judgment and decisive decision making and the ability to oversee employees, but if they don't actually do it, you don't fit under the exemption and you're headed for liability under a DOL audit, okay? That's the flow chart that you need to be following. So a lot has changed. The salary test in and of itself is a massive change. That said, so far, the DOL has not messed with a whole lot of things. Obviously, the $913 and the $47,476 is a big change. They threw a bit of a carrot out there and said, well, you can take 10% of bonuses or commissions, other non-discretionary payments that you give to employees, and you can take 10% of that as long as you pay it quarterly and attribute it to the $47,476 number to try to help employers get to that number. In truth, 10% doesn't really help all that much. If someone sells $40,000 worth of stuff in a quarter, that only improves their salary rate by $4,000. But it's something. And again, it highlights the need to track that type of compensation on a quarterly basis in order to utilize it. You can also make catch-up payments at the end of the year to maintain someone's status as exempt with the $47,476. So that also is another thing that has changed. Keep in mind that $47,476, unlike its predecessor of $23,660, it's not static. It will change. So every 3 years, there's going to be a cost of living analysis, and all of these numbers are going to change. So the $47,476 is going to go up in 3 years. The $100,000 that's currently in place for highly compensated Going up to 134, that number is going to expand as well in the next 3 years. Just some funny stats, not so funny, but what were the impact of these changes? What does making this threshold at a new higher number actually do? Well, from at least some studies that I've seen, this will impact employers by an estimated $1.8 billion per year in increased labor costs, overtime, wages, everything that comes with it. 4.2 million workers, this is conservative estimates coming out of the Department of Labor, 4.2 million workers in 2016 will be impacted by these changes. And here in Ohio, conservatively, again, 134,000 employees will be affected by this change just on the issue of the threshold wage rate. Okay, so that is what changed. What didn't change, at least so far, the Department of Labor has not tinkered with the exemption tests. So the exemption tests for executive, administrative, professional, computer sales, computer techs, outside sales, highly compensated. They haven't messed around with the tests for those exemptions yet, but they are certainly rattling their sabers and making clear that that is coming as well. So be on the lookout for new and exciting changes when the person who I think is going to win the election is going to win the election. There's going to be more of the same coming out of Congress, coming out of the rulemaking authorities in the EEOC, DOL, OSHA. You're going to see a continuation of these policies going forward, not a change. So with the exemption tests, everybody still feeling comfortable that you know what is exempt versus non-exempt? Okay, good. Somebody's waffling in the front. You should waffle. It's not clear. But the administrative one is the one that trips everyone up, so I'll just tell you what the administrative test is, and you'll see why it's so confusing. The majority of an administrative exempt employee's time have to be spent on meaningful decisions that are directly tied to the benefit of the company, where the person uses independent judgment and decisive decision making. That means not, gee, I feel like ordering a bunch of paper clips today. It has to be meaningful decisions that impact the company. So administrative assistants, even though administrative is in their name, that is not an exempt employee in virtually every case. Just because you call someone the vice president of the loan department does not mean, and they dress up in a suit and even a tie, which we did not do, that does not make you exempt. That does not make you exempt. So the administrative exemption is the one that trips people up. If you're a professional, if you fall into the professional class, you pretty much know whether or not you're going to fall into that exemption. Executive, are you supervising or managing people? Do you have an executive title? Are you in the C-suite? Are you a supervisor or manager, fairly high grade? That's easy. It's the administrative one that falls prey to a lot of problems. So that's what we came to talk about in terms of the change, but that doesn't mean that that's all there is to worry about in DOL land. Far from it. While this is a fairly major seismic shift in Department of Labor rules and regulations, that doesn't mean the DOL is sitting still and doing nothing in all kinds of other fronts, and we wanted to alert you to some of the biggest ones that may be plaguing you and or your clients. So this has been going on for years now, but misclassifications, that has been the DOL's main target for quite a long time now. And not only the exempt versus non-exempt misclassification issue, which we'll continue to talk about, but independent contractors. Anytime the government comes out and in the strongest possible terms says, if you are using independent contractors out there, you bad companies, and you think that you're fooling anybody, you've got another thing coming. We're coming after you. The IRS is coming after you. We've got a new and exciting partnership with our friends in all of the different governmental agencies. And if you are using independent contractors, you're kidding yourselves, because we know their employees, you know their employees, and you're basically all a bunch of tax cheats. And we're coming for you. And they said it in the clearest terms. When the government tells you they're coming and they've got a target, listen to them. So if you have independent contractors working at your companies or clients of yours are heavily reliant on independent contractors, you need to take a serious look at whether or not they're truly independent contractors, because the government is telling you they are not in most cases. Bless you. Unpaid interns and volunteers. Summer is almost officially gone, but summer is a great time for unpaid interns and volunteers. We'll talk a little bit more about that, but that has been a target for the DOL for a long time as well. So independent contractors, just real quick, they announced a new test which deviates from prior thinking, but the one word I would want to have you leave with today when you're trying to figure out whether someone is an independent contractor versus an employee, it's one word, and that is control. Who controls the relationship? And it's all different kinds of control. It's control over the individual's time. It's control over the way the person is paid. It's control over the way the person is bonused or compensated. It's control over their work life. Are they wearing uniforms? Do they have business cards? Do they have an email address? Do they have an office? Control, control, control. Whose tools are they using? Control. Whose vehicles are they driving? Control. All of those things will lead a Department of Labor investigator to think that the control is with the employer, and therefore it's an employee relationship and not an independent contractor relationship. If you have independent contractors, first step, while it's not a silver bullet, it's certainly the best indication that there's a true independent contractor relationship, and that is a contract. So having an independent contractor agreement that clearly spells out the relationship from the get-go, there's no hide the ball between the parties, a B2B relationship, a company to an individual LLC, a company to even just an individual, have it contractualized so at least you're not painted with the brush of trying to play games with the individual in addition to the government. So you want to have a very clear understanding that the individual is not an employee, they're not going to be getting benefits, they're not going to be subject to overtime, they're not going to be subject to workers' compensation or any other kind of tax withholding. You want that clearly memorialized in a contract. The test is now what's called an economic realities test. And I list out the various questions here that you should ask yourself when trying to determine whether or not there's an independent contractor relationship. Is the work an integral part of the employer's business? If it's integral to the employer's business and other employees are doing it inside, chances are hiring someone from outside to do the very same thing, they're not going to be deemed to be an independent contractor. Does the worker's managerial skill affect his or her opportunity for profit or loss? If they have no ability to change the way that they're paid, they are looking a whole lot more like an employee than an independent contractor. How does the worker's relative investment compare to the employer's investment? If the employer is providing all the tools, all the stuff in order to do the job, and the independent contractor is coming in with a pencil and that's it, they look a lot like an employee and not like an independent contractor. Does the work performed require special skills and initiative? Again, if there are other people walking around the company that can all do what the independent contractor can do, they don't look so independent anymore. Is the relationship between the worker and the employer permanent or indefinite? I have clients that say, oh, I've got this whole group of independent contractors. They're working out there. They've been with us for 13 years. I've heard it. I've heard it. You cannot have a 13-year relationship with an independent contractor. It just can't happen, okay? They are employees. And knock on wood, they have not gotten caught for doing this, and they have not changed despite my best efforts. Oh, the employees love it. I mean, the independent contractors love it. Yeah, they love it. They love it until they get nailed for tax cheating as well as the employer. So if you're born under a lucky star and you cross your fingers and want to go to sleep very lightly every night, keep doing that stuff because eventually some rotten apple's gonna upset the apple cart. What is the nature and degree of the employer's control? Again, control, control, control. None of these questions, by the way, in and of themselves win the day one way or the other for independent contractor versus employee. But the more of them you stack up, if it walks like a duck, quacks like a duck, to a DOL investigator, it's a duck. And that duck is an employee. Okay. Unpaid interns. Not the biggest issue, so I'm not going to spend a lot of time on it, but this issue did get some good press when our friends at who created the film Black Swan with Natalie Portman, Mila Kunis, Fox Searchlight was the production company. They thought it was great. They thought they were doing a service to the Hollywood community. They said, hey, everybody, send your kids down to this great movie we're producing. We'll have them do all kinds of fun stuff. They'll get to rub shoulders with superstars and Natalie and Mila and all the great stuff, and they'll learn a little something, and we'll get some good use out of them. It'll be a win-win. Well, it was a win for Fox Searchlight because they got a whole lot of free labor. And what these interns were doing was a lot of the work that they would typically have showrunners doing, assistants doing, and they were doing compensable work and not getting paid for it. So this was a class action lawsuit. It went up and down and back and forth, and eventually at the end of the day, the courts have come down with, again, another big, long test to try to figure out whether or not interns may be unpaid or paid. Just as a general rule, I'm not going to go through the whole test, but if the relationship does not at least equally, if not more so, benefit the intern than the company that's bringing them on, it should be a paid endeavor. So internships are still fine, especially if they're getting college credit for it, other high school credit, or whatever kind of credit. If there's an educational component to it, okay, you can possibly do an unpaid internship. But in every other case, chances are you should be paying at least minimum wage for the interns. Class actions. If there's one area of the law that has exploded more in the last 5-10 years than any other, it's the explosion of class action lawsuits, predominantly in the Fair Labor Standards Act arena, but in lots of others as well, Fair Credit Reporting Act, and clearly EEOC and others. But class action lawsuits are all the rage these days. And it's not just big companies that are getting hit with class action lawsuits. There is an attorney who shall go nameless here in this town, who used to work for the right team, defense, but he saw a wonderful opportunity out there in the Fair Labor Standards Act to be a plaintiff's attorney, and all he does is sue companies, class action style predominantly, for wage and hour violations. Anytime there's a law out there, Fair Labor Standards Act, Fair Credit Reporting Act, any kind of technical law, it's ripe for class actions because it's very hard to get every aspect of these laws correct all of the time, and to do it not just in one location but in multiple locations. And class action lawsuits are particularly difficult to defend because you've got lots and lots of plaintiffs, which equals lots and lots of discovery, which equals lots and lots of depositions and mess and finger pointing and attorney's fees. And that's the attraction of class action lawsuits. So here I would just throw a couple of the biggest area class action lawsuits out there, the improper exemptions, exempt versus non-exempt. If employers are treating employees as exempt and they haven't been tracking time and they haven't been paying overtime, that is a ripe area for class action lawsuits. Off-the-clock work claims, which we talked about before, being suffered to work when they are off the clock, the automatic deduction for the 30-minute lunch or the hour lunch, and the supervisor grabs the employee and says, oh, if you could just help me clean off this machine, that would be a big help. Well, you're suffering that employee to work. They're no longer on unpaid time. They should be compensated for that time. Lots of employers get it wrong all the time, and that results in class action lawsuits. Just a few stats: 8,126 FLSA cases filed in 2014, dramatic increase from 2013, and I think we're seeing it level off a little bit for 2015, but the stats haven't come out, but there's still an enormous number of class action lawsuits being filed in Fair Labor Standards Act land. Those numbers, by the way, do not include lots and lots of state actions. We're talking just about the federal. Yeah, Lamar?
Real quick, if an employee works at home, checks email for half an hour on behalf of the company,
Yep.
that counts as time, doesn't it?
We are starting to see, and John will undoubtedly talk about this a lot. Yeah. This is the new frontier of the remote worker. And guess what? If you've got a phone on your hip or in your pocket, you can do much, if not most, of what you do at the office. So we're starting to see a proliferation of lawsuits being filed, not just class action, but individuals as well, claiming that they weren't compensated properly for paid, what should have been paid work. Class action lawsuit explosion. So when I asked the question before and you all raised your hands, all full of vim and vigor, saying, I know what's an exempt employee, I know what a non-exempt employee is. Well, look at all these huge companies with all their law firms and their HR departments, and look at the numbers they are getting hit for. Some of these are settlement numbers. So if they settled for 7 figures, guess what the ask was? It was probably 8 figures or 9 figures. So big companies, LinkedIn, Merrill Lynch, Verizon, Taco Bell, even some rather humorous ones like the Oakland Raiders got class action sued by their cheerleaders. That started a wave of class action lawsuits. My own Buffalo Jills filed a lawsuit against my Buffalo Bills, and these poor cheerleaders have been beset upon for years because they get paid a flat dollar amount. They don't get compensated for all the practice time. They tried to force all these charges on the cheerleaders, and finally someone said, you know, this can't be right, and they were right. So the Oakland Raiders started a torrent of wage and hour lawsuits in the NFL. And Tyson Foods, all the food companies, all the chicken processing and nasty businesses like that, they get sued left, right, and center by the DOL, not just for wage and hour violations, but they're big wage and hour violators because of donning and doffing. That is not a law firm. That is actually a term of art. So donning and doffing. Anyone know what donning and doffing is? See, Lamar, you come to too many of my seminars. You know all the answers. Gold star for Lamar. That is correct. That is donning and doffing. So if you require your employees to put on hazmat suits or more than just putting on their Cintas uniform because of a safety issue or something that goes on with the process, chemical plants and things like that fall prey to this, then they should be compensated for putting on that required uniform before and taking it off at the end. A lot of employers get that wrong, especially Tyson Foods. They've gotten hit for it a bunch of times. So, what can you do to protect yourself against the class action explosion? John's going to talk a bit about that, so I will pass the baton on to him.
Thanks. Mr. Bliss.